Here.
Yes.
First, the series matter from item number 15 to 28. These matters have been substantially heard by the Court of Honorable Justice Mr. Said.
Is
The
it?
order says that it's for further hearing. Can
Okay.
it be reported back?
Yes. Today, because of some exigency, it has
Sure.
come before us before. Other counsel are agreeable to this proposition? It is jointly submitted that these matters have been substantially heard by another bench within bracket Honorable Justice S. Sikhe and was fixed for further hearing. Full stop. It appears that only because non-availability of that bench today, these matters have been listed before this court. Full stop para. In the interest of justice, registry is directed to verify and list these matters before the appropriate bench.
Okay.
This will be item numbers
15 to 20,
15 to 29.
29, 28.
28. 29 is different. Okay.
Obliged. Application. 10 for listing and this petition relating to competition fairly matter tomorrow.
Motion.
Not for admission.
Admission tomorrow. Why?
Competition heavily bad for the other.
Why admission? What is the urgency for tomorrow? Which matter of which year?
Year 2023. The class listed on 6/12.
No, not tomorrow. How can we have it tomorrow? Is it urgent? Well, why do you list a matter out of turn? Because of some urgency? It's not urgent. Why tomorrow? Not, sorry.
My lord, I'm listing tomorrow for withdrawal.
Withdrawal. Okay, withdrawal, yes.
Okay.
With the content of the other side, I mentioned item number 9, but is getting late. But we are filing one reply affidavit today. We inform the other side. Come up on the date towards the end of May or June.
What is the matter about?
The matter relates to my lord, payment of fixed pay allowance.
Okay. Yeah, for the bank.
I am for the respondent.
3A Ganguly, Learned Council, appearing for the AGVB.
Yes.
Assam Gramin Vikas Bank, AGVB, submits that the affidavit in opposition. Affidavit in opposition?
Reply affidavit. Additional affidavit.
Why additional affidavit?
Look, some I have taken leave earlier. The dummies order is there. Taken leave file.
That an additional affidavit is being filed today, which is being done after taking leave of this court. Full stop para. In view of the, he accordingly prays for taking up this matter on any other day. Full stop para. List this matter for hearing on today is 9th. On when? Tell us, 16th?
4th of June.
4th of June.
Or 30th.
On 30th of May. Full stop. The reply affidavit that may be filed today be tagged with the record.
May I please?
It will be 30, no? 35. Yes.
I beg to mention for listing, madam. The matter relates to non-payment of areas cleared.
Listing of which
next
bench?
week.
Bench?
My lord, bench relating to bench 3.
Sorry? Bench 3, there is a senior bench.
My lord, there is a notice, my lord.
Bench 3, there is a senior bench, so not.
Salaries, my lord. Notice chair.
For what? Motion?
No, my lord, admission.
Admission?
Yes, sir.
Matter of which year?
2022.
22.
Yes.
When was it last listed?
Last listed, my lord, 22 March 20.
What had happened then?
My lord?
What had happened then?
My lord, that order I am allowed to amendment.
Have you amended?
Yes, my lord.
You have
Already filed,
amended?
already filed.
Okay, when do you want?
Next week, 17th. Okay.
Yes.
Sir, also, I beg to mention item number 10. Sir, also,
Yes.
the matter may be adjourned for the day, as my senior learned counsel is not present due to as he has to perform rituals of his father's death
Who,
anniversary.
who is your senior?
A Sumwa.
Inform the other side.
Yes,
Yes, health department you have informed.
yes, sir.
A prayer for adjournment has been made on behalf of Sri A. Chamo, Learned Counsel, for the applicant, citing some personal grounds. Put the para list after a week.
May I please, my lord? I beg to mention for listing the matter WPC 276.
Which bench? Which bench?
Single.
Which bench? We know single bench. Bench 1, 2, 3, 4, what?
One.
Bench 1 is not here, madam. Is bench 1 here? Yes.
Yeah, please. Not it. So maybe kindly typing.
Hmm?
Senior advocate, the Jain Sahayata is on late.
Okay, 15 matter, we're not adjourning. Ask him to come. What is the issue, madam?
My lord, the petitioners are praying for a pension scheme, my lord. They are retired prior to 2007, my lord. And there was no.
How can you pray for a scheme, formulation of a
My lord,
scheme?
there are certain instructions from the.
Isn't it the
government.
prerogative or the discretion of the employer? Can we direct framing of a scheme for persons who are retired more than a decade
My lord,
back?
certain directions are there from.
Okay, we'll let Mr. Sahola come, we'll hear you.
At 2.
No, not at 2. 2 o'clock, there's a larger bench. In the first hour itself, after some time, after a while.
May please, sir. Matter pertains to non-payment of family pension. The husband of the petitioner serving as a constable under DSF and he discharged from service
Just a minute.
Well.
1560. Husband was serving as what?
constable under the border DSF
PSF.
DSF.
Okay.
He entered service on 13/6/2060.
13/6.
1960
1960.
1960.
Yes.
And thereafter he discharged on medical ground on 1/8/1969.
Yes.
Thereafter the respondent granted pension with effect from 1/9/1969.
Yes.
And thereafter he expired on 13/9/2006.
Okay.
During course of his lifetime the husband of the petitioner filed representation before the authority to nominate the petitioner as because he married after discharge from medical ground. And thereafter after some communication the petitioner approached before this honorable court kindly stay page 38. Annexure 14.
Page
Page 38,
38.
38.
Yes.
heard Mr. E. Ahmed, learned counsel of the petitioner.
You had come to this court earlier.
My lord, earlier,
Earlier on occasion you had come to this court.
my lord,
4001.
my lord.
14, yes.
Yep. May I read, my lord?
Yes, yes.
The petitioner is the wife of late Procedural Rajbangshi, who was working as constable number so and so under 84 Battalion BSF. He had entered into service BSF on 13/6/1960 and was discharged on medical ground on 1/8/1969. He received pension with effect from 1/9/1969, height pension order dated 26/1972, and continuously received the same till he expired on 13/9/2006. During his lifetime, he made a representation to the respondent number 3 for nominating the petitioner, his wife, for the purpose of family pension. After expiry of her husband, the petitioner made represent for family
Okay, we
pension.
have seen this.
My lord.
We have seen this. We have read this.
Thereafter, my lord, the impugn order passed, my lord. Kindly see page 40.
40.
40, my lord.
Yes, please.
Paragraph 2, my lord. It is to inform that your husband, namely late Constable Sasator Rajbangshi of this unit, was proceeded on invalid pension 1st August 1969, for which family pension is not admissible as per Central Civil Service Pension Rule, my lord. Denied pension, my lord. The husband of the petitioner already received the pension, my lord, till his death, my lord. Thereafter, denied family pension.
Now they have cited the CCS pension rule.
My lord.
Is there any bar in the rule?
My lord, the respondent filed affidavit in the affidavit opposition stating that, my lord, the husband of the petitioner has not completed 10 years of service, my lord.
No. They have cited a reason that it is not admissible as per Central Civil Service pension rules.
My lord.
Are you agreeable to this proposition that the rule, as per the rule, you are not entitled to family pension? Or is it a wrong interpretation made by them?
As per CCS pension rule, my lord, the qualifying service 10 years, my lord, as my lord, filed by the affidavit, my lord, stated that, my lord. The husband of the petitioner completed 9 years, my lord. And in after my lord, receiving the pension, my lord, obviously the wife received the family pension, my lord.
No, it cannot be an obvious. It's a family pension is a different aspect. Pension for the person during his lifetime is a different aspect. What does the rule say? If the rule says that you are entitled, then you may have a case. If the rule says that you are not entitled, then unless you challenge the rules, we may not be in a position to grant you any relief. Is there any provision in the rules for relaxation?
Relaxation, my lord. Yes, my lord.
If 10 years is the qualifying period, there may be a provision for relaxing this period.
Relaxation rule 88, my lord, CCS pension the relaxation.
Yes.
Power to relax.
Yes.
Where any ministry or department of the government is satisfied that the operation of any of these rules causes undue hardship in any particular case, the ministry or department, as the case may be, may by order for release to be recorded in writing, dispense with or relax the requirement of that rule to such extent and subject to such exception and condition as it may consider necessary for dealing with the case in a just and equitable manner. Husband of the petitioner, my lord, served, my lord, 9 years, 1 month, 18 days. He received the pension, my lord, and a question arises after receiving, after my lord, death of the, my lord, husband.
How long did your husband serve?
Served 9 years, 1 month, 18 days.
The 10 years minimum requirement
10 years.
is in which rule?
Rule, my lord,
And that pertains to the pension or family pension?
my lord, pension, my lord,
Pension,
pension, my lord.
page, rule, which rule?
39, my lord.
Thirty-eight.
38.
38 is invalid pension.
Invalid pension.
Yes, what does it state? Is there any? Where is the time?
My lord,
Is it also limited by time, that minimum length of service you have to put in?
Forty 49. Rule 49, my lord.
Rule 49 is amount of pension. It is amount of pension. Is there any period prescribed for being eligible for pension in case of a invalid pension?
For invalid pension, lordship, subject to Rule 49. Rule
49 is the amount of pension.
amount of pension before completing the service of 10 years.
Where,
49, page
where,
49.
yes, which 49 what? Sub
Clause 1, my lord, 2B, my lord.
2B.
In the case of a government servant retiring in accordance with the provision of this rule before completing qualifying service of 33 years, but after completing the qualifying service of 10 years, the amount of pension shall be proportionate to the amount of admissible under clause A, and
Intervention.
in no case of amount pension shall be less than 20.
Before completing 10 years, lordship, he is entitled to gratuity. But after
But you had paid him pension.
yes, lordship, but we have not paid pension. It is the Accountant General Assam has paid the pension. We are not the party at that time. PSF was raised in only in 1965. And at that time, the Accountant General was the authority to disburse pension. lordship.
He was working under whom initially?
Initially, under the Assam government, but it was a battalion, Assam government battalion who border.
No, my lord, BSF, my lord. BSF, my lord.
PSF was in 1965. It was formed in 1965. He was appointed in 1960. And they have also filed an affidavit, Accountant General.
But all these years he was receiving a pension, and you have a power to relax. The service put in is 9 years, 1 month,
9 years.
and it is invalid pension. He could not have served the.
Invalid pension, he is not in invalid pension. 10 years requires to become.
No, but you had,
paid the invalid
but
pension.
he was being paid.
It was not even invalid pension. He is entitled to gratuity, not pension.
No,
because
what
he
he
has
was
not completed
entitled
10
to,
years.
what he was entitled to, what you have paid.
Already paid, my lord.
We have not paid, it is paid by the accountant general.
After it was paid by the accountant general, after 65, did you stop the pension?
It was, no. In
You did not
2000,
stop.
till his death, it was paid
So when did he die? He died in 2006.
2006.
From 65 to 2006, you kept on paying.
Since the old cases were not verified. In 1960,
Now, is it,
as per the
will it be fair? Will it be reasonable?
as per the accountant general.
You are not
affidavit-
denying that the present petitioner is the widow,
Yes.
number one.
But
If
there
that
is
fact
some-
was put
in
to
that
denial,
also there is some dispute, Lord.
hmm,
As per their own
what is the dispute?
regarding the date of your marriage.
Now, are you raising that dispute
No, no, it's a-
regarding the marital status
My
of
case is
the?
that we have not paid any pension to the petitioner's husband. And it is the accountant general, and on what basis the accountant general paid, whether it is regular pension, invalid pension, or disability pension, it is not known. And
Accountant general might have paid till 65. From 65,
16,
huh?
yes.
From 65 to 2006, the money has gone from you. You cannot say that we have not verified.
Then to 1976, it was Assam accountant general. They have admitted it.
Till 76, from 76 at least.
Thereafter, department.
86, 96, 2006, 30 years you have paid.
Yes.
You cannot say that we have not verified.
Also not verified it.
You cannot say.
Yes.
Even 1 paisa you have to verify.
Even it is wrongly paid on the basis of that the
You have the power to relax rules. You have not exercised that power. The impugned order at page 40 is not on the aspect of exercising the power of relaxation. In a given, we have read the language of section 80, rule 88.
88.
It is an exceptional case in a particular case. It may not be in a general nature, case to case basis. You apply your mind to that. We may not say that the petitioner is straight away entitled, but the husband of the petitioner, without any dispute, has been getting the invalid pension for the last from 1969 to 2006.
Six.
Okay. You have filed affidavit, madam.
yes, I have already said.
Third, Sri. No, I don't know like this. An order dated 5/12/2015 passed by the BSF authorities, whereby the claim for family pension of the petitioner has been rejected, is the subject matter of challenge in this writ petition. Full stop. Para. Bereft of details, comma, the facts projected by the petitioner is that her husband Sasadhar Rajbangshi was appointed as a constable in the BSF on 13/6/1960. Full stop. While in service, comma, while an order dated 1/8/1969, comma, the husband of the petitioner was discharged from service on medical grounds. Full stop. Upon such discharge, comma, the husband was getting invalid pension throughout his lifetime. Full stop. However, on the death of the husband on 13/9/2006, comma, the petitioner has not been given the family pension. Full stop. The petitioner had filed representation before the authorities. And the same was followed by filing of a writ petition, being WPC 4001 of 2014. Full stop. The same was disposed of by this court wide and ordered it 22/8/2014 to consider the case of the petitioner. Full stop. Pursuant to the said direction, comma, the impugned order has been passed on 5/12/2015, whereby the claim of the petitioner for family pension was rejected. Full stop. It has been stated in the order that such claim was not admissible as per the CCS within bracket pension bracket close rules. Full stop. Para. I have heard Sri K.R. Padgiri, learned counsel for the petitioner. Full stop. I have also heard Miss R. Devi, learned CGC, representing all the respondents. Full stop. The,
Newly implemented accountant general.
the BSF authorities. AG, anyone for AG? R.K. Talukdar? Sri R.K. Talukdar. Is he there in the court? Is the Sri B. Chakraborty, London Standing Council, Accountant General, is present. Please ask him to come once. Para. Sri Padgiri. The materials be placed before this court, Taragota, Line to Likiba, have been duly considered. Types of. Then you come. Sri Padgiri, the learned, please have your seat.
My lord.
Sri Padgiri, learned counsel for the petitioner has submitted that denial of the family pension to the petitioner would be absolutely unfair and unreasonable, inasmuch as there is no dispute to the marital status of the petitioner, being the widow of the deceased employee who had passed away on 13/9/2006. Full stop. It is also submitted that since the marriage was after the discharge from service, comma, representations were made to nominate the petitioner as the nominee, inasmuch as the nominee, full stop. It is also stressed that till the death of the husband, comma, he was getting the invalid family pension, and therefore the entitlement of the petitioner cannot be denied. Full stop. Para. On a specific query by this court on the power, on the aspect of the minimum length of service, comma, the learned counsel has submitted that Rule 38 read with Rule 49 would make the position of the what question of the rules would make the position clear. Full stop. Under Rule 38, comma, Rule 38 deals with invalid pension, and Rule 48 is on the amount of pension which stipulates 10 years of a minimum period of service. Full stop. The rules, however, contain a provision in the form of Rule 88, which gives the power of relaxation. Full stop. Under the aforesaid provision, comma, in case of undue hardships in any particular case, comma, the requirement of the rule may be relaxed to such extent in exceptional cases, with a further rider that concurrence from the Department of Personnel and Administrative Reforms is to be taken. Full stop. The learned counsel submits for the petitioner, submits that reading of the impugned order dated 5/12/2015 does not indicate that there was any application of mine towards applying the provisions of Rule 88 while taking the decision. Full stop. Para. Per contra, comma, Ms. Devi, the learned CGC, has submitted that the impugned order dated 5/12/2015 does not suffer from any legal or factual infirmity. Full stop. It is submitted on behalf of the respondents that there is no manner of doubt that the deceased husband did not complete the minimum length of service so as to entitle the petitioner to claim the family pension. Full stop. On a query by this court as to the fact of granting invalid pension to the husband till his expiry in the year 2006, in spite of not meeting the minimum length of service, comma, the learned CGC has submitted that at the time of induction, at the time of appointment of the petitioner, comma, the BSF was yet to be formed, which was constituted in the year 1965, and till 1976, comma, the invalid pension was paid through the Accountant General. Full stop. She has also clarified that all cases were not verified, and therefore the pension was paid to the husband of the petitioner during his lifetime. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The fact regarding the marital status of the petitioner is not in dispute. Full stop. It is also not in dispute that on discharge of the husband of the petitioner on medical ground, on 1/8/1969, comma, he was granted the pension, invalid pension, till his expiry on 13/9/2006. Full stop. This court has noticed that the minimum length of service as prescribed in the rules to be entitled for invalid pension is 10 years. Full stop. The petitioner's husband had served for a period of 9 years, 1 month, 18 days, in spite of which, comma, the authorities took a conscious decision to grant him the pension throughout his lifetime. Full stop. The explanation sought to be made on behalf of the respondent authorities that initially such pension being paid by the accountant general, comma, the same was not detected. Full stop. Such explanation, however, though may be technically correct, comma, is not acceptable in view of the fact that the subject matter involves pension to a member of the force who was discharged on medical ground and the period of service rendered by him is 9 years, 1 month, 18 days, which is marginally short from the strict requirement of 10 years. Full stop. Para. Be that as it may, comma, the issue of receipt of invalid pension by the husband of the petitioner during his lifetime was never raised, and all along he was getting the same. Full stop. The question therefore arises that on his death, whether the family pension can be denied to the wife of the employee on the ground that the employee did not complete the minimum length of 10 years in service. Full stop. The petitioner is aged, a petitioner, comma, as would be revealed from the materials placed on record, would be currently aged about 6, 7, 8, 75 years. Full stop. This court has also considered the provision of Rule 88, which reads as follows. Rule 88, Para. The aforesaid rule clearly bestows a power to relax any rules if it causes undue hardships in a particular case, and in such cases, comma, the requirement of the rules can be dispensed with or relaxed to such extent to arrive at a just and equitable conclusion. Full stop. As noted above, comma, concurrence of the Department of Personnel and Administrative Reforms would also be required. Full stop. Para. The impugned order dated 5/12/2015 does not from a reading of the impugned order dated 5/12/2015, it does not appear that there has been any consideration towards applying the provisions of section 88 of the rules, even assuming that on a strict application, the petitioner may not be held to be entitled for family pension, full stop. As observed above, the fact of payment of invalid pension to the petitioner, to the husband of the petitioner, during his lifetime for a period from 1969 to 2006 may itself be a ground to continue paying the family pension to the wife of the deceased employee, that is the petitioner, full stop. However, even if the rules are strictly applied, the present facts and circumstances makes it a case wherein the power of relaxation is required to be applied and appropriate orders be passed for grant of family pension to the petitioner, full stop, para. In view of the aforesaid facts and circumstances, and taking into account that the deceased husband of the petitioner had served the BSF for a period of 9 years, 1 month, 18 days, the remaining period to qualify, to meet the qualifying period of 10 years is required to be considered by invoking the powers under Rule 88 of the rules. Full stop. The aforesaid direction, the impugned order dated 5/12/2015 accordingly stands set aside, and the matter is remanded back for a fresh consideration in accordance with the observations made above, full stop. The order, the consideration and consequential order is to be passed expeditiously, as the petitioner is aged about 75 years. Full stop. The 75, and in any case, within a period of 3 months from the date of receipt of the certified copy of this order. Full stop. The petition accordingly stands allowed. Obliged.
May it please, Your Honor.
Yes.
My lord, this is a case filed by the Welfare Association of Retired Employee of Association, ONGC.
You are a registered association.
Yes,
Registered association. 107.
I pray lordship to go page 3 of the writ petition, my lord.
Page 3.
Please.
Yes.
Last cause title. The provision of the prescribed optional right of the retired ONGC employee to elect any one benefit out CPA and pensions and provide under the statutory CPF Act officially, which was also adopted by ONGC. They were not provided the option for pension or the minority CPF. They are only provided the option of CPF. They could not opt for pension. Their grievances is main grievance is that. And now they are in the fake end of life minor, and they
You are getting CPF,
yes CPF.
not pension. You
Not
want,
pension.
you want pension.
Yes, my lord. Pension means, my lord, some financial assistance, because the CPF account which they got already lots of finished, my lord, and such a high price, and at the fake end of life, and ONGC is the one of the richest company in the within Asia. So there, my lord, there is a flossing may kindly go to the annexer B1 directly.
Now, what is the basis of your claim?
Basic claim is that
No, what is the basis?
basis, my lord, B1 loss, you will find there is a
Page
page 26,
26.
26. This is the office memorandum from Department of Government of India, Department of Public Heavy Industries and Public Enterprises.
2009.
Yes, 2013, January 2009. This is my subject process will go, my lord. Recommendation of second PRC on creation of a corpus by contributing 1% to 1.5% of PBT profit before tax by CPS to take care of medical and other emergency needs of retired executives and the others who are not adequately covered by the pension scheme. Examination thereof, my lord. This is a office memorandum
Yes.
where, my lord, 1% of to 1.5% of, my lord, profit to be kept reserved for the employees, my lord, who retired without pension, my lord. For the this is a recommendation of the pay revised committee, my lord. And on the basis of this, my lord, recommendation, two office memorandums are there. This is B1, B2, page 27.
This is a recommendation.
These are recommendations.
Recommendation by which the views of the
Pay
CPSCs were called for. Read paragraph 2. Ministries, departments concerned with the CPSCs are requested to furnish their concerned views. This is the recommendation.
my lord.
Okay, what happened to the recommendation?
Next, my lord, annexer B3 is there.
Accepted or not?
Accepted, my lord. My lord,
Page.
the ONGs did not follow this recommendation.
No. What is the, was this? Where is the acceptance of the recommendation?
Office memorandum, my lord, 20 July 2011.
Page.
Page, my lord, this is annexer B3.
B3. Okay, page 30. Page 30. 20 July 11.
2011.
What happened here? Or
Here, my lord, direction have been issued to the CPSCs under the administrative ministry department to contribute not more than 1.5.
They have been decided, and Mr. may consider creating one corpus so. Yes. Percent. 15. Yes.
These recommendations were not followed by the ONGC. And thereafter, they preferred one, my lord, representation.
Who?
Our Petitioner Association.
When?
This is, my lord, annexer C, page 32. To the Prime Minister, this is on 24th August 2011. Prime Minister
Before.
and the Minister for Petroleum and Natural Gas, Government of India. This representation.
Yes.
Where they have prayed for a sympathetic pension
This was given by whom?
by the petitioner, my lord, petitioner associate.
Where do you get it?
Below my lord. Page 35.
35. Now, who's the signatory here?
36, my lord.
36.
Ruganath Gorthakur.
He's one individual. He's one individual. Doesn't matter.
My lord,
Is he an office bearer of
he is the president.
president? Okay. Okay.
There are signatures. They are not
Doesn't
before.
matter. I will
My lord.
consider this to be a
Page 35, lordship. Their prayer, lordship, my lord.
yes.
Prayer for implementation of a standard rational pension scheme covering all the retired employees based on the minimum of the scale pay and to revise pay scale 2007 for ONGC employee. This was their prayer, my lord. To issue ONGC shares of rupees 4 to 10 lakhs face value free of cost to each retired employee in recognition of their patriotic service as architect of ONGC and economic freedom fighters. Breakup should be as 4 lakhs to class 4 employee, 5 lakhs class 3 employee, 6 lakhs to 10 lakhs to class 2 and class 1 proportionately distributed. This was the and the third prayer is return restore the Golden Jubilee Award of rupees 50,000 and 15 grams gold. This was the prayer, my lord.
But this prayer is not connected with 27/2011 1.5 PBT. This you said that you introduce a pension scheme,
Scheme, my lord.
issue shares, restored Golden Jubilee Award. How do you connect your representation at page 32 with the acceptance of the recommendation at page 30?
My lord. My paragraph 3, lordship,
Yes,
page 2.
yes. Yes.
That's to our great surprise and pain. We would like to apprise that due to the utter negligence, business irresponsibility, and safe motherly attitude of ONGCL authority, the pension scheme of the retired employees have been kept in the cold storage for last 20 years, in spite of the fact that the government of India, right in 1991, have already decided and instructed all the PUCs to create welfare fund for retired employees with 1.5% of their annual was their matter. On the basis of this, my lord, this representation was filed, submitted, my lord. In response to this representation, there is a reply, my lord.
Yes. Reply is where? Page?
Page. My lord, page 37,
37.
Annex D. This is from the manager, HR department, my lord, ONGC.
What has been stated?
My lord, here, my lord, they have rejected the two, my lord, prayers, my lord, for goal. This is first one, they have stated, my lord, pension to retired employees, number 1, possible fund.
Yes.
ONGC being considered to the cause of retired employees has designed a draft scheme to give some financial benefit to the retired employees who separated on or before 31/12/2006 to take care of their emergency needs. A proposal to this effect has already been submitted to ensure as soon as it is approved, Ministry of the scheme shall be implemented. This is a date of 2012 matter.
Yes.
And then other to pair, they have rejected my. share and the golden jubilee celebration that they have. Thereafter, they have felicitated the, my lord, retired employees, my lord, who attended 70 years, they have given 20,000, who 75 years, 25,000, 80 years, one time, my lord. On attending that age, they have given, this is very less amount, my lord, 20,000 is nothing. And on attending 75 years, they get 25,000, one time, my lord. Thereafter, they have introduced one scheme, my lord, as Asa Kiran. Lordship will find in paragraph 13. I have stated in my petition, my lord.
Yes.
This Asa Kiran, my lord, was introduced, my lord, for emergency need of the petitioners, members of the petitioners association, my lord, for medical or other.
Okay.
This Asa Kiran has some, this is, my lord, Annexer E, page 38. No. Asa Kiran, Annexer F, page 39, my
39.
39.
Yes.
A scheme for extending financial assistance to the employee retired prior to 1/1/2007 for taking their emergency need. This is a scheme, my lord.
Hmm.
This scheme was only for the year 2012 and 13. In this scheme, maximum 2 lakhs was offered, my lord, for their emergency need, 50,000 for and 60,000, but 2 lakh they have not paid. They paid only 1,10,000, 50,000 for emergency and 60,000 for, my lord, medical aid. But there are certain formalities. They have to apply, they have to give document, authentic document, and two board that are there, they have to approve these things. These people, my lord, they are already above 80 years, my lord. They cannot do these things, my lord. So their prayer is that you give certain amount annually so that they can, my lord, receive it directly to bank without going through this proper formalities, my lord. Though this scheme is not, my lord, continued after 2014. The procedure is there, my lord. Page 40, management of the scheme.
This is not continued.
This is not continued. Thereafter, the petitioner, prior to this scheme, the petitioner approached this honorable court, my lord. There was earlier petition, my lord, last annexer,
Yes.
page 55, my lord. The order passed by this honorable court. But during the pendency of this, my lord, read petition, the Asa Kiran was introduced, my lord. Page 56, Lord.
Hmm.
Here, my lord, second paragraph, referring to the additional affidavit filed by the respondent number 2 and 3, so-and-so James Sahela, learned senior counsel, assisted by so-and-so learned counsel representing the ONGC, submitted that considering the matter in its entity, the ONGC has issued guideline under the name and style of Asa Kiran, that is so-and-so, confirming various benefits to the retired employee of the ONGC. He submitted that this guideline will take care of the grievances of. For this, my lord, the case was closed and liberty was given if their grievances is not, my lord, fulfilled, and they has the right to come to the honorable court case. That's why the petitioner is before your lordship today.
Is Asa Kiran continuing today?
Asa Kiran not continued. Thereafter, petitioner submitted another representation.
No,
my
some other schemes are continuing.
No, my lord.
No,
No,
such
some
schemes.
medical emergency need has been given, but this is not sufficient because they are now suffering for bread and butter. They need some money annually or monthly. They are all above 80 years. And so few people are living, my lord. All are maximum, my lord, already died. Because they are retired prior to 2006, my lord, 2007. Already some people are there. Not much money is required, my lord. If they continue the Asa Kiran and they pay from 91, from the day of the, my lord, central government, then also they will get some benefit, my lord.
91 means
91 means the day from the issue of the, my lord,
Asa Kiran is in 2013.
13, my lord. But the government instruction 2009. Government instruction is 2000, central government instruction to create a corpus for.
No, that was a recommendation.
Yes, from that they give it accept the effect and pay some amount. Then their grievances will fulfill, my lord. And if
No,
annually,
2009 was a recommendation by which the views were asked for.
yes,
It cannot be held to be applicable. 2011,
2011 is there, my lord.
27, 2011,
yes.
1.5% PBT was to be contributed. That is your case.
My lord.
How many of you are there? How many?
Exact number? 200 or less.
You are working where? In Nazira and Sibsagar?
Another part of the country.
Other part of the country. Huge number.
But still Nazira Valley.
Hmm?
Basically, they are from Nazira.
Okay, Mr. Sayola.
My lord, you will also see what is their prayer, madam. That statement of the petition.
90?
Page 22, after it. Their prayer.
Yes.
First, implement the liberal pension scheme. My lord, pension is not applicable to Supreme Court. Says, my lord, that is, I can say that. This is first prayer, my lord. Second prayer is to share of rupees 4 to 10 lakhs, free of cost. Right, no matter the purpose. Then three, restore Golden Jubilee Award. Then fourth is implement financial scheme under Asakiran. Asakiran, my lord, by removing content disparity, as mentioned by the petitioner. Right, not answer. Asakiran is there, my lord. They have to apply, my lord, they have to follow the all the guidelines. They say that they cannot do it. That is not the matter.
Asakiran is there or not?
Yes, it is there.
But
It
the
is
petitioner said that
it is
no,
there, my
Asakiran
lord.
is
They have to apply, my lord. Their details are there.
Where is the where statement that Asakiran is still
My lord,
existing?
they filed an appeal. My lord, one affidavit was filed on 17/5/17.
But Mr. Sayola,
My lord,
yes, you may be correct in contending that so far as 1, 2, and 3 are concerned, that cannot be claimed as a matter of right.
Right.
The only question is the implementation of the Asakiran.
and
What-
another, it
what-
will also see the affidavit, my lord, how many schemes are implemented by the government, my
No,
lord.
no, we are on that only. Madam has said that they are sufficiently aged persons.
Yes.
We will not go to a particular case, but we generally let us assume that they are sufficiently aged. Somebody may not have a person to help them. Why don't you have a nodal kind of an officer or office to facilitate any such applications to be verified or documents to be verified? Have an officer, have an employee. It's only to facilitate. There and around how many? 200, 300, 500. And it may be a matter of fact that old age person without any help, even there is a scheme, they may not be able to avail the scheme. You can just make the scheme more practicable and implementable. Have an officer to facilitate. That much I think you can do.
My lord, it will also see, my lord, that page
And it should
79.
be a
my
part
lord.
of the scheme itself.
My lord, page 79.
79, yes.
Yes, in our affidavit, my lord.
79.
In our affidavit, my lord, dated 6/10/2015.
You file affidavit in 2015.
15, my lord. There, my lord, we have annexed various schemes, my lord. they are getting benefit of those, all those schemes, sir. From NISA A series, my lord, and there are series. Various schemes are there, sir. They are getting benefit. And says, my lord, government of India,
79, let us read.
the government of India says, my lord, that the criteria should not be relaxed.
Which paragraph?
My lord,
20, page 79?
page 79, my lord, paragraph 1, 2, my lord, is there.
79.
I am directed to refer ONC letters number speaking approval of the company authority for implementation of the scheme of the Asa Kiran for taking care of emergency needs of the retired employees and. to
Okay,
convey
this is at
approval.
136.
Yes.
Not 17, 136. This is letter of 1st of July.
Yes, 1st of July.
Yes, please. Please read.
I am directed to refer to the ONC letter dated 22nd May 2013 seeking approval of the company authority for implementation of the scheme of the Asa Kiran for taking care of the emergency needs of the retired employees and convey the approval of the company authority for implementation of the apostate scheme with the following motive. 4.1 modified as a committee of directors will be constituted by the board of directors to provide guidance for smooth implementation of the scheme. Power to relax eligibility criteria under clause 2.2 is proposed to be given to CMD under clause 6.9. Generally, eligibility criteria should not be relaxed, but exceptional circumstances demand so it may be done with the prior approval of the MOPNG. Accordingly, wording of the clause may be modified. It may mention the scheme that annual contribution of ONC to the corpus will be decided by board of directors ONC based on the projected requirement, but should not exceed any year 1.5% PET for the previous year. It may also mention the corpus will be prudently managed, guidance of committee of directors to under financial support will be provided by the government for the scheme. May be decided to this nature of emergency, other can be this is. The last, as regards to a ceiling of 30,000 may be stipulated per case file. Now, this is the government of India side. And besides that, my lord, if you also see, so many schemes are there, page 27 onwards, the next slide.
Page
Page 27 onwards, my lord, is
27.
in the affidavit. Several schemes are there. This is first creation of corpus in order to take care of medical or other emergency needs of the retired employees of the CP. This is one, my lord. Page 27.
No,
Then
just
30 is another, my lord.
Just a minute.
Paragraph also we have given, my lord. If you look
Just a minute,
to
please.
page 4, my lord.
Medical care.
Page,
Hmm.
page 4.
Page 84, page 27 is scheme of 87/2009.
9, my lord.
Yeah.
Details of given, my lord, is page 4, my lord. Of the
Page-
page 4, my lord. Yes.
All the
Yes, all.
schemes. Page 4 paragraph.
My lord, it paragraph started earlier, my lord. Page 3, 6, paragraph 6, my lord. Where we say that they cannot get any pension and other things, my lord. Then, without prejudice, my lord, this page 4 stated that employees have already got the benefit of the scheme. Furthermore, with regard to the welfare of the employee, has already implemented various beneficial schemes for its retired employee, like post-retirement benefit, organized criteria, post-retirement benefit, employee pension, so and so. Now it is come. As per DP, almost so and so, create a corpus of 1.5% PBT in order to take medical care of medical and other emergency needs of those retired employees who are not covered by the pension scheme and post-pension medical benefits. The retired employee are very much covered for medical needs. So the following ongoing post-retirement medical benefit scheme, the scheme provides for full medical coverage equivalent to regular employees as per actual reimbursement of the OPT expenditure and 100% indoor expenditure. So credit notes in various renowned hospitals across the country wherein ONGC operates. Besides these following medical welfare schemes are already in operation to take care of the retired employee. Medical TA as per entitlement of employee, reimbursement of the cost of hearing aid 60,000, reimbursement cost of 85,000, reimbursement cost auto PAP 70,000, reimbursement cost of oxygen concentrator 60,000, reimbursement cost nebulizer up to 3,000, tackles up to 5 to 12,500 every 2 years, artificial appliances 4,80,000, wheelchair up to 1,80,000, reimbursement cost of nursing care up to 1,000 per month. Besides that, above medical benefits, in case of emergency, the fire, food, earthquake, etc. Ex-employees are supported
Yes, we
by.
have read,
My lord,
we have read this.
yes. Everything is, my lord, given, my lord, to them.
What is your take on this, madam?
Well, this is for emergency need. If the it is caused medical benefit and other things, my lord. But now they are suffering, my lord, for bread butter. At least a amount from this 15%, my lord, before tax. This
No,
from this corpus, they can pay some
there-
amount annually.
Can this be a ground that you are
Well-
suffering now? For your emergency has been taken care of. There are number of schemes that in case of any need,
My lord, these things are
now
not all are working,
how
my
you
lord.
survive, you have to survive. Why, whatever scheme was there at the time of your retirement.
It's
It's
my
not
lord,
that,
they
it's not
can-
that you have been left high and dry, severed, nothing. It's not like that.
For implementation of the Asakran, that has not been, my lord, given.
That has also been implemented.
Yes, it is there, my lord.
Asakaran, he has made a statement,
Yes.
Asakaran is being, is
Yes, still there.
still implemented.
Yes.
And your difficulties for that, we can may pass some directions.
My lord.
There would be a nodal officer who is meant for this to facilitate any application
My lord, that-
for verification, filing of applications,
yes.
that you can do.
After all, they have to give some details, my lord. That
See,
can-
Madam Borman may be correct in contending that in a given case, family of old persons, nobody to help them. In spite of there being a scheme, they are not being able to utilize this scheme. To facilitate such utilization, you have a dedicated office, nodal officer. That will, I think that will serve their purpose.
Well.
Okay, heard. Ms. P. Borman, Learned Counsel for the
Your
petitioners.
lordship permission may. my lord.
Yes. Also heard Sri G. N. Sahawala, Learned Senior Counsel, assisted by A. Singh for the ONGC. Anybody for Union of India? Union of India, you're there? Sri C.K. Sharma Barua, Learned CGC, is also present. For the para. The writ petition has been structured with making the with the following relief. Please. Prayer ko ye kar dीजिए, page 22. Full stop. Para. The Learned Counsel, Miss Burman, the Learned Counsel for the petitioner has submitted that the petitioner is an association of retired employees of the ONGC and are mainly concerned with with the deprivation of an adequate post-retirement benefits, with an adequate scheme for post-retirement benefits. Full stop. though it is admitted that the petitioners are, that the members of the petitioner number 1 are getting the CPF, comma, a scheme should be directed to be framed so that they get regular pension. Full stop. The learned counsel for the petitioner has referred to an office memorandum dated 13/1/2009, whereby there was a recommendation for creation of a corpus from by contributing 1% to 1.5% of the profit before tax, PBT capital, within bracket PBT. The said recommendation, after consideration, was accepted via communication dated 27/2011, wherein an amount to the ceiling of 1.5% of PBT was directed to be contributed. Full stop. The petitioner association had thereafter submitted a representation dated 24/8/2011 on the three major aspects. Small one, number 1, pension scheme. Number 2, issuance of shares. Number 3, giving benefit pertaining to the Golden Jubilee. Full stop. The said representation was, however, rejected, responded to by the ONGC via communication dated 30/4/2012. Full stop. While the prayers numbers 2 and 3 were rejected, comma, it was informed that a scheme was under consideration. Full stop. The petitioners had thereafter instituted WPC 3329/2013 before this court. Full stop. However, comma, in the meantime, the scheme of Asa Kiran, inverted comma, was introduced on 15/10/2013, and on being apprised of the said development, comma, the aforesaid WPC 3329 of 2013 was closed via order dated 4/11/2014. Full stop. Para. The learned counsel for the petitioners, petitioner, has submitted that the said scheme of Asha Kiran was only for a particular year, 2013-14, and the maximum amount was for 2 lakhs, out of which effectively only 1.1 lakh was made available at the time of emergency. Full stop. This said scheme has not been continued thereafter, and therefore the petitioners are suffering from immense hardships. Full stop. She further contends that the aspect of their survival has also come into question in absence of a regular pension, as the CPF benefit was not sufficient for their livelihood. full stop. The learned counsel has also highlighted the aspect that even for availing the benefits of the existing schemes, the process is cumbersome, and they being sufficient, and the members of the petitioner number 1 association being sufficiently aged, they are not in a position to fulfill the formalities, as a result of which the schemes have turned out to be futile. Full stop. Para?
One thing, they were at the time of retirement, they were not given the option
No.
for the pension matter.
The
They
learned
were
counsel,
only paid. Yes.
the learned counsel has also submitted that the petitioners were not given the scope of opting either for CPF or pension, as a result of which they have been illegally deprived of the pensionary benefits. Full stop. Para? Per contra, Sri Sahewala, the learned senior counsel for the ONGC, has submitted that none of the prayer numbers 1, 2, and 3 cannot be matters of adjudication, as those are within the prerogative and domain of the employer. Full stop. As regards the 4th aspect of the Asa Kiran scheme, the senior counsel submits that the said scheme is in continuation and the petitioners are getting the benefit of the same. Full stop. Para? Referring to the affidavit in opposition filed on 27/11/2015, the learned senior counsel has submitted that apart from the Asa Kiran scheme, there are several other schemes for the benefits of the retired employees of the ONGC. Full stop. By drawing the attention of the averments made in paragraph 6 of the affidavit in opposition, the learned senior counsel has submitted that details of all the existing schemes are given, which are presently available for the petitioners. Full stop. It is submitted that the question of giving option would not come, as the existing mode was adopted at the time of retirement of the members of the petitioner number 1. Full stop. Para? On consideration of the rival submissions, this court is of the considered view that the prayers pertaining to a direction for introducing a pension scheme, issue of shares, and restoration of the Golden Jubilee benefits cannot be claimed as a matter of right, as those are within the domain of the employer. Full stop. However, having held that, this court would certainly look into the aspect as to how the retired employees of the PSU in question are being treated. Full stop. Para. The submission made on behalf of the petitioners that the Asa Kiran scheme was only for a year has been refuted on behalf of the ONGC, and the materials on record would show that the aforesaid scheme is in continuation. Full stop. There is no dispute to the facts that a number of other schemes for the benefit of retired employees are also in existence and continuing. Full stop. The details of the details of the schemes which have been stated in the affidavit of opposition are given briefly as hereunder. Page 61 se, kara dega full stop. This court is therefore unable to concur with the submission made on behalf of the petitioners that they are left high and dry after their retirement. Full stop. However, the aspect that the petitioner that most of the members of the petitioner number 1 are sufficiently aged and are not in a position to to fulfill the formalities for availing the aforesaid benefits is an issue which this court has pondered. Full stop. Para. The ONGC, being one of the largest PSUs, is also under an obligation to ensure that apart from floating these schemes for the benefits of the retired employees, they are also to ensure that such schemes are being practically implemented by facilitating the employees to fulfill the required formalities. Full stop. Towards an effective implementation, this court accordingly directs the ONGC to have a dedicated nodal office headed by a responsible officer to facilitate any retired employees of the ONGC to fulfill the pre-requirements to avail the benefits of any existing scheme. Full stop. Such assistance may be granted in a liberal manner so that for mere technicalities, the benefits are not, any retired employees are not deprived from the benefits. Full stop. This, of course, has to be done in a bona fide way as public money is involved. Full stop. Para. With the aforesaid directions, the writ petition stands disposed of. The aforesaid, the last line say the aforesaid direction for creating a nodal office be done expeditiously and preferably within 2 months from the date of receipt of a certified copy of this order. पेज 66 से हम लोग ये कर देगा, कोट करेगा क्या डिटेल्स है वहां से भी education, yeah.
Three, I think, man, four may be taken up. Three, to some extent,
Four
marked
is
with-
5864.
yes, 5/8/6. That also marked with this, my lord. This case, what happened, my lord, that the petitioner was the headmaster of the high school initially, man. And
You were headmaster.
he was headmaster in a high school. Founder headmaster, ultimately provincialized since 1991. In
Of a
90
provincialized high school.
provincial high school. And he was founder headmaster. Accordingly, he became a provincialized, and he was appointed as headmaster with effect from 1911-1991.
Hmm.
Thereafter, the school was upgraded to higher secondary class. Higher secondary class started. Many committee has taken a decision to put him as principal. Of
No,
the
it was high school initially,
yes, initial high school,
Oh, okay.
provincial high,
then upgraded to higher secondary.
high to higher secondary.
Okay, then
Then my lord, up in the higher secondary, that means class 11 started. So while during 11 started, the managing committee appointed him as regular principal of the higher secondary school. Since
him.
yes, this person, my thereafter, my lord, post were allotted to the school principal as well as other teachers. They allotted to the school, higher secondary school. So he treated himself, my lord, as principal of the school, higher secondary school. And accordingly, he submitted bill with endorsement of the inspector of the school for regular, my lord, scale of pay. Then thereafter, my lord, actually they put him as in charge principal. After submitting that, my lord, that bill, order has come that he will be treated as in charge principal.
Which order?
That is, my lord, your lordship will find. That is not annexed here, but in the representatives there, my page 39, your lordship will find.
Can you give the date?
Yes, I'll show, my lord, that date. Hold on, yeah. Yes. This was, my lord, 25th March 1996.
You are treated as in charge principal.
In charge, my lord. No, that's simply it was stated by the headmaster of the school will act as principal in charge of the school until further order.
Hmm.
So especially I have not named, but since I was the headmaster, so I stated to be in charge headmaster. Yes. Then I have submitted an application to IS that this should be regular principal instead of in charge principal. And that was forwarded by the IS.
When was it done?
Yes, that was forwarded, my lord, page 42. It was forwarded on 19/1/2012. 12.
Forwarded by whom?
Forwarded by Inspector of Schools. In respect of my application dated 10 November 11, 2011. I submitted a representation that should be modified, treating me as a regular principal of the school.
Which inspector of schools, Karimganj?
No, it will Nalbag. No. So my representation, page 39, 10 November 2011. Thereafter, my lord inspector, he has forwarded it. Then what happened, my lord? They started saying that I have drawn the regular scale of pay in spite of the fact that I have been put as in-charge principal. Issued a show cause notice, put me under suspension. But whole thing is done through the knowledge of the inspector of schools, man. And he was doing bona fide, this bill has permitted. Page 43, suspension was made on 16 September 2014. 14. 16,
Page
page 43,
43.
suspension.
And show cause notice?
So in this, my lord, proceeding is called for. Here it is simply written proceeding is then proceeding is called for. Simply they have written where above allegation calls for a departmental inquiry Now, department proceeding is called for and drawn up against Mr. so-and-so. Hence, so-and-so is put under suspension with immediate effect as per provision of 6 of the so-and-so. Further order on substitutions allowance will be made. Therefore, I file an appeal against that. My lord, this
Suspension order.
suspension order, page 44. Page 44. Yes. Thereafter, my lord, on 20/10/14,
20,
20/20/10/14,
10. Yes,
page 48.
yes.
The show cause is now proceeding, my lord, show cause notice issued to me. The why, my lord, penalties mentioned in Rule 7 should not be taken. Page 48.
What is the charge?
My lord, charge is that you are acting as in-charge principal of the school, but you draw your salary as regular principal, whereas you were posted as in-charge principal. You have violated official role and misused the power of PDO for your personal gain. You are therefore charged with breach of trust, misuse of power.
Okay,
40, page 48.
you replied.
I replied, next page, page 50, I replied.
50,
Page 50.
reply,
Yeah.
denied.
Yes, I denied. I said that point of my revision of pay was also made during that as a principal. And managing committee also appointed as principal immediately after upgradation to higher secondary school. Then page 50, next 14, my that is dated 28 October 14.
Your reply.
My reply. And thereafter, again what they stated, page 51.
Yes.
Another shock notice issued to on the same line.
Okay, the date.
Yes. And page after my retirement.
After your retirement.
After I retired on 31st January 15.
This second so-called, another so-called notice when?
That is dated 2nd January. It was served me on 7/2/15.
2nd January.
7. Oh,
2nd
yes.
January
2nd
2015.
January 15.
Served on?
Served on 7/2/15. And received on 12/2/15.
No, you said served on 7/2. You received on 12/2,
Yes.
not 7/2.
7/2/15 and received on
No, you
12.
served and received. What is the difference?
Oh, issued my endorsement, page 51 is mainly.
No, you said it is dated 2/1/15.
Yes. Dated 2/1/15, but in the left type, my bottom.
Served on 12/2.
Yeah,
You received on 12/2.
12.
And you said it issued all even on 7/2.
Yes,
Yes.
sir. Dated 7.
Issued on 7/2.
Dated 2nd January 15.
It was issued on 7/2. You got in 12/2.
12.
Yeah.
Okay, 3 dates.
After retire.
3 days. When did you retire?
I retired on 31st January 15.
Okay,
This was challenged in item number 3.
okay.
This one.
3254.
325. Yes, no. Yes, 325. First one, no. 3, my item number 3.
Yes, 3254.
Yeah.
Your challenge.
Then my lord, what happened? Thereafter, they have passed the impugn order, page 50.
Page
Page
15.
53.
53.
Yeah. 10 August 15. After my
Just a
retirement,
minute, please.
53.
'53.
Yeah.
10 August.
Yeah. 10 August. A report
10,
from
8/15.
Yeah.
This is the impugned order.
Yes, this is the impugn order. In the present item number 4.
Yes, what is this?
A report from Inspector of Schools Nalbari was received by his letter number so and so. The Inspector of Schools reported that Sor Anchalik High School in the district was upgraded to higher secondary school by the government letter dated so and so. And 10 numbers of posts, including that at the post of principal, your lordship got it, was principal was allotted to the upgraded higher secondary school. It was provided in the post allotment order that the existing headmaster will act as in charge principal.
No, what had happened to 3254?
It is still pending.
No, was there any order passed?
Now, in that case, it is notice was issued to them, they filed.
Now, after filing of the writ petition, this order has come.
Yes, after filing, the pendency of that writ petition.
Okay.
Yes, this order has come.
What has been stated?
Yes, it was provided in the principle that the post were communicated to the principal and others by his office number so and so. It was clearly mentioned in the post allotment order that the headmaster of the school will act as principal until further order. The report of the inspector of schools, Nalbagi dated so and so revealed that Muhammad Shahjahan Ali, in charge principal, was drawing salary of the regular principal with effect from the state of upgradation of the school. It was a financial irregularity and misuse of financial power that was invested to the principal. Having satisfied that the Mr. Shahjahan Ali committed financial irregularity and misuse of power, the department proceeding was drawn, and Shahjahan Ali was placed under suspension by this official number so and so, which is at page number so and so. Definite charges were framed against Muhammad Shahjahan Ali and were communicated to him by this official number 2115. The following charges were framed against the delinquent government servant. The while in service as in charge principal, he had drawn deliberately his regular scale of pay of the principal that was not due to him. As such, he was charged with fraudulent activities and breach of trust. The government servant, here it is interesting, madam. The government servant, despite communication of charge and statement of allegation, did not submit any reply. It is not actually correct.
Okay.
The government servant, they said that I have not submitted a reply. Reply it is already there, my. Inquiry officer was not appointed since the disciplinary authority himself was the inquiry. When no reply was submitted or received from him, the following letters were issued to the delinquent government servant. These letters, my. The director for information was requested to publish a notice by this office letter number. The public notice was published and the copy is on the record. Since the delinquent government servant, despite communication of the charges and statement of allegation, did not submit any reply, it is presumed that he has nothing to say. The charge frame stands proof. That cannot be. Even suppose I have not replied, even that cannot. That to proceed, it must have a natural conclusion. But here I have submitted my reply also, and that is under challenge also. So the charge frame stands proof. That is in violation of my Lord, your Lordship, 9, 6, and 7 of the disciplinary rules.
Okay.
Then the delinquent government servant submitted an appeal before the Secretary of Education Department on 15/10/14. I have perused the copy of the appeal petition. He states that Sor Anchalik High School was provincialized with effect from 16/11/1991. The delinquent government servant was regular headmaster of the school. Sor High School was upgraded to Sor Higher Secondary School. The delinquent government states that, your Lordship, the managing committee allowed him to act as principal of the school. At paragraph 5 of the appeal petition, he states that since he was holding the post of principal since 1993 and the post of principal was allotted, he was entitled to draw the salary of the principal of the high school. The defense, as stated in his appeal petition, does not hold water.
Okay, okay, we have read this. Okay, yes.
Since the
No,
post,
not required to, we have read this.
yeah.
Yes.
So now this is the case, my lord. Now your Lordship on page 34, my lord.
3/4.
Page 35.
Yes.
Page 34 and 35, both. your lordship.
35, yes.
Yes. 34, my lord.
34,
Yeah.
yes.
On page 34. With reference to the subject stated above, I am directed to say that Government of Assam is pleased to accord permission to open class 11 in Chor Anchal High School, Nalbari, without post. Your Lordship, kindly see, without post permit. After this, my lord, the managing committee allowed me to appointed me as a principal. I have it here. Then post was allotted, page 35. Page 35. Your Lord, page 35. Under the authority of government letter number so and so, upgrading 82 high school into higher secondary school with due creation of different categories.
Okay. This you are going into the merits.
Yes,
You are going into the factual merits.
Factual
May not be required.
yes.
Anything else on the legal part?
The legal part now, my first question they have violated that is, I have not submitted reply, that's not correct. There it stands proof that cannot be made. It must have.
Where is the conclusive proof that you have submitted reply?
Yes, it is there.
No, your it's annexure is there.
Yes,
No, any acceptance by them?
yes, your lordship.
Please.
Your lordship, reply is page 50.
50 is your reply.
Yeah.
No, is there any endorsement that it was received?
Thereafter, your lordship will find.
Any letter of receipt?
That of course, my record will.
Okay, doesn't matter.
Yeah, any.
Even assuming that you have not replied.
Suppose,
Worst case.
even then,
Worst case.
my,
Okay.
even then I cannot. Even then.
Okay.
Now, my lord, after now recovery, my pension, they are now paying that pension on the basis of that initial stage. But my leave encashment, other nothing is being paid. My care, your loss kind is my care in the. Yes. And additional affidavit I have paid, what my lord, suspension regularized. Pension also allowed to be on the basis of earlier one.
Given.
Yes, yes. Pension is given on the, we have 10,000 something only.
As the headmaster of the high school. Pension
Yeah, additional affidavit, your loss will find page
now given
flex C, my.
at the rate of as headmaster. Then
Flex C, your loss.
flexi, no, what are you being given? Pension as
Yeah.
headmaster, then
Then,
leave encashment given.
no, nothing.
Okay.
So I have my lord nothing here. Paragraph 5, my lord, of my page 66.
66.
Yes.
Yes, please. Yes.
He was placed under suspension on 16/9/14, allowed to do something else.
Your suspension allowance pay.
No, nothing.
Not paid.
That was not paid. 2 months.
Till now.
Till now. 2 months salary also not paid.
Suspension allowance not paid.
Subsidy not paid. Revised area, cash. Yeah. Paragraph 8 also, your lordship, my paragraph. Paragraph 8, my lord, page 58.
Okay.
Just my lord, just 3-4 lines. So
Now what are you challenging now here?
now, because recovery, they have stated about recovery of that year. Recovery of the whole.
When did you retire?
Retired
31/1/2015.
31/1/2015.
Okay.
And my encashment, my lord, respondent pay before the
Okay. Yes.
area salary,
No,
then
those, if you can,
revised PA.
Mr. If you can make out a case.
Yeah.
For interference with 10/8/2015, others will be taken care of.
Yeah.
You are challenging 10/8/2015.
That one.
Any case law you are citing?
Yes, that Rafi Masih case is there.
No, that is on the aspect of
No, that is the,
holding up of pay. What
Ah.
about the imposition of the penalty?
no, penalty matter, only recovery, the penalty is only recovery.
No, to interfere with the recovery, it is given after a DP, unlike Rafiq
So,
Masi.
yes, the DP also not.
Here there's a DP, there are charges.
Yeah,
In Rafiq Masi, other whitewasher case, there is no
yeah,
charge as
that
such.
is symptom matter.
It's only a calculation. We found that you had drawn more amount, so
that-
we want to
Some
recover. The
some
Honorable
principles
Supreme
are
Court has
given in
laid
the-
down that for this category, you should not,
Yeah.
unless there is fault attributable to the employee in making a wrong calculation.
Calculation plus hardship also, there might some.
Hardship or everything. Now here is your case is slightly different.
Yeah,
Your recovery has come as a consequence
Exactly.
of an imposition of a penalty
That's-
for recovery.
that-
Okay. Any case law on the penalty part, how a penalty
No,
can be
penalty part I
prescribed?
have not, my lord.
how a penalty can be prescribed as per the 1964 rules.
Your lordship, for a 2019 5 GLT, Gujatana, Gujatana,
What was 2019?
2019 5 GLT 774. I have not called my lord today.
7-7.
774.
What has been said?
Yes, okay. Expect clear.
Any paragraph?
Madam, giving you a expect clear. Expect clear. 11, 10, 11, 12. In
10, 11, 12.
In the instant case, it appears that on being dissatisfied with the purpose, the Honorable Supreme Court in the case of so and so has held that even in case of temporary government servant, the safeguards prescribed have to be afforded in a case the penalty was thought to be imposed. In the present case, it is seen that the procedure prescribed in the Rule 64 has not been followed, rendering the impending order of termination void ab initio. The long period of service rendered by the petitioner, which is also a relevant factor, has also been totally overlooked by the disciplinary authority. In view of the above, this court does not have any other option but to set aside and quash the order dated so and so. As a consequence, the petitioner would be entitled to be reinstated in service with all notified benefit. However, the principle no work, no pay, the petitioner would not be entitled to any. So that is slightly different, but question, my lord, the same proceeding was in that case, my lord, that was set aside. But I'm handing over both. Another.
What is your submission, your take on the 1964 rules?
Yeah.
What is the prescription of the rules?
Yes, your lord, kindly see.
So,
9, 6, and 7 is. First, my lord, Rule 9, your lost.
Rule 9.
Rule 9. 64 rule.
Yes. Rule 9.
Yes, without prejudice to the provisions of the public servant, no order imposing on a government servant any of the penalties prescribed in Rule 7 shall be passed except after an inquiry held as far as may be in the manner hereinafter provided. The disciplinary authority shall frame definite charges on the basis of allegation on which the inquiry is proposed to be held. Such charges, together with the statement of the allegations on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified in the disciplinary authority a written statement of his defense, and also to state whether he desires to be heard in person. Then 3, your lord, the government servant shall, for the purpose of preparing his defense, be permitted to inspect. Then 4, 5, 6, your lord's command. Then 6. The inquiry authority shall, your lord's got it. The inquiry authority shall, in the course of inquiry, consider such documentary evidence and take such oral evidence as may be relevant or material in regard to the charges. The government servant shall be entitled to cross-examine the witnesses, examine in support of the charges, and to give evidence in person and to adduce documentary and oral evidence in his defense. The person presenting the case in support of the charges shall be entitled to cross-examine, and then the witness examine so and so. If the inquiry authority decline to examine any witnesses or to admit any documents on the ground that this evidence of so and so is not relevant, it shall record his reason so and so. Then your lordship will find 7. At the conclusion of the inquiry, the inquiring authority shall, your lord, prepare a report of the inquiry, recording its findings on each of the charges together with the reasons thereof. The record of the inquiry, the 8, records of the inquiry shall include the charges framed against the government servant and the statement of allegations furnished to him under sub-rule 2. his written statement of defense, if any,
Hmm.
in any oral evidence taken in the course of inquiry, the documentary evidence in the course of inquiry, the orders, if any, made by the disciplinary authority and the inquiring authority, a report setting aside the findings on each and the reasons on. Thus, even the shall, if it is not the inquiring authority, consider record of the inquiry and record his findings on each charge. None of these provisions has been followed. So without following this pilot, it cannot be with this impunity order cannot sustain. This is the case.
Yes, Mr. And we'll hear Mr. Khataniar will come back to you if needed. You can address on the legal point.
Yes, ma'am.
Factual, what are the charges, what has happened, we may not be too much
Yeah, my lord,
concerned as a secondary authority, as a writ court.
admittedly, my lord, he drew regular.
We are not
regular
on that,
principle.
we are not on the allegation,
that-
we are
that-
on the procedure.
Yes, ma'am. He drew regular scale of pay, my lord. He admitted it, my lord. That's why, my lord, otherwise there is no requirement of to conduct a formal inquiry, my lord. Since, my lord, he has admitted the charges level in the so-called notice, my lord. It's
Where is,
admitted, my lord.
where is the admission?
Yes, ma'am.
Admission of fact and admission of guilt are two different aspects, Mr. Khataniar. I can make a candid disclosure. Does it mean that my culpability has been admitted?
My lord, here,
If
my lord,
if it's in the form of a charge,
it's
then the initial burden, not the initial, the entire burden is upon you to at least prima facie prove the charge. What steps did you take to prove the charge?
Uh,
Did you examine a single witness or a document? Did you hold an inquiry?
we have furnished the
Notice?
charge memo.
Yes.
Charge memo.
You said that he has not
He has
replied.
not replied, my lord.
Okay, then
He has not
matter ends there.
He has not replied, my lord, and subsequently, since in the appeal filed by him,
Appeal is subsequent.
yes, not subsequent, my lord.
Appeal is subsequent, not a reply to the show cause notice.
No, appeal is before that, my lord. It's appeal is dated, my lord, 10, I think 10.
Yes.
Appeal was before the secretary.
Yes, my lord, before the secretary.
Is what is this appeal? Under what provision of law?
Under 14, my lord.
14?
Under Assam Service Disciplinary Appeal.
Which provision of law? 14.
Yes,
Suspension, again suspension. my lord.
Suspension.
But on that appeal, there was an admission that he drew.
Suspension is a different aspect. You have drawn some charges against him. Yes, even assuming that he has not replied, your duty will not end there. At least you have to have a semblance of an inquiry.
That
Have
was-
the,
Admittedly,
not
that was not
done.
there. Admittedly, that was not there.
you have not done.
Admittedly, that
Even
was
at
not
least
there.
a formality you have to have, call the witnesses, record some statements. He is not there, not there. You are not bound to have his presence, even if he comes on his own volition that I am not going to participate. It will not end like that.
Yes.
You can go ahead,
Yes, my lord.
but you have to fulfill the formalities.
That was not compared only because that there was an admission on his part.
Let us
In
see
fact,
again, let us see your contention, examine your
That-
contention.
that is
Where is the
reflected
admission?
that is reflected in the order itself, my lord.
No, not the order. We'll not go by the order. Let us see the admission.
Admission, yes, my lord. Page 45, my lord. Page 45, my lord. Paragraph 5. That
Suspension. Page 50 to get up. 50. After that, it's not. Of course, reply.
This 44, I think, is for rule 14.
rule 14.
It is pertaining to the suspension
Suspension,
order.
my lord. Pertaining to suspension. In that appeal, my lord, in paragraph 5 and 6, there was an admission, my lord.
Let us read.
Paragraph 5, my lord, that after upgradation of Shore Anshalik Higher Secondary School into Shore Anshalik High School to Higher Secondary School by the order dated 12/3/96, the post of headmaster in the high school was automatically abolished as per as the post of
Mhm.
principal was allotted by aforesaid order to so and so. Since the appellant has been holding the post of principal from
Khataniar, Mr.
1993.
Khataniar, these are statement of facts. These are not admission of guilt at all. Where is the culpability that I have done this? I have indulged in this misconduct. He says, what has happened has happened. This is the facts.
Yes, sir.
And in any case, it was an appeal under 14. Even construing this to be a statement which you can consider, but this you cannot construe to be admission. Number one. Number two, let us come to the next reply at page 58,
Yes, sir.
I think.
Yes, space 50, madam. 50.
50.
Yes.
50.
Same thing.
50, you have stated that you have not received this.
Yes, sir.
No, he is not paid.
No. That is there.
Yes,
The
madam.
impugned order has stated that this
Yes,
was not
madam.
received.
There was no reply. There was no reply.
Yes, there is no reply. What is the date of this? 28 October.
It is 28 October, madam.
Is there any admission here?
No specific admission here, sir. No
Hmm?
specific admission.
No admission and 28 October. And 28 October 2014 and impugned order is 10/8/2015.
Here, madam, only paragraph last before one paragraph, madam. As a post of headmaster of high school being upgraded to higher secondary, hence I drew my salary as principal, which was allowed in the IPS that was passed by the IS and this onward. So he admitted that
How much is the difference otherwise? Have you
Prince, I have
you walked out?
no, madam.
Because the order of penalty
No, madam.
is
Or
at 10/8/2015 is only for the recovery of the amount, excess amount,
Yes,
which he might have drawn as the principal.
principal.
And excess obviously has to be construed in terms of his earlier posting as headmaster of the high school.
Yes, sir.
So how much would be the difference?
That difference, Mr. Madam.
Have you recovered anything?
No, madam, because we have only paid him to the provisional pension, and we have regularized the suspension period. So what will be the amount that has to be worked out?
No, recovery will come only when you may have made some payments.
Yes.
Have you made payment of salaries also?
Salaries, my lord. Arrears, he's here, my lord, he's asking for arrears salary for that particular period, but during the period of suspension. We have regularized that period, and we have paid he drew the
Salaries
for
as a headmaster.
principal as principal.
He drew.
Yes, my lord, he drew, my lord. That is the allegation.
No. You said that the salaries were held up. He was under suspension.
Yes, my lord.
For the suspension period, you have
Suspension.
regularized the period
Yes, regularized.
by making payment of what salary? Salary as headmaster or salary as principal? Number one. Number two, if you have used the expression recovery, that means you must have already paid some amount which, as per you, he is
Is
not
that-
entitled.
Yes.
Have you made any payments?
No one.
Then where does the question of recovery come?
Payment, he has already drawn some amount. Till his suspension, he has already drawn some amount. But after suspension, my lord, what will be the outcome?
No, see, there is another twist here because he has retired on 31/1/2015.
15.
So once he is retired, the question of salary will not come. It is only the post-retirement benefits. And how do you calculate the post-retirement benefit? On which scale?
Yes.
Now, what are your prayers, Mr.
My prayer was
Sorry?
on page 18. And
1/8?
page 18 and 19. For setting aside the impugned order dated 10/8/15 issued as so imposing penalty of recovery of excess toil from the petitioner. Each amendment should be issued directing the respondent to release the retirement benefit pension and area salary to the petitioner. And my area salary, my dot in the suspension regularized order they have written, Shahjahan Ali, principal so and so, who was suspended with effect from so and so, is hereby regularized for granting pensionary benefit as well as full pay of suspension period as per rules in force. Page 78. So that also not been paid. Subsidy allowance also not paid. 2 months salary also not been paid, 2 months salary. Yeah,
Mr. Khatonier, we see, so far as the allegations are concerned, we may not say too much on the allegations. You may have a case, but what we are concerned is that you have not followed the procedure. We will set aside this order of recovery of 2015. Normally, we would have remanded back. We are just thinking over that.
Yes.
But here is, we are dealing with an employee who has retired about a decade back. So how can you suggest any, we will not record it. Can you suggest anything where his grievances can be taken care of and your state exchequers can, interest can also be protected? It can come from you also. We will not record in the order.
but the question remains, ultimately he sacked. He had discharged his duties as principal. It is admitted. Inspector of
No,
School,
so far as your serving is concerned, your salaries are concerned,
yeah,
we may not touch upon that aspect.
that is,
You have served,
Yeah.
but how do you compute your
no, that's. not a
compute
spe-
your
salary.
pension?
In fact,
Pension?
he has, bona fide, he has submitted his bill with endorsement of the inspector of school.
No, Mr. Chaudhary, salary part we may not touch. Whatever you have got, you have got,
Right.
or whatever you are still entitled to get as salaries.
So rest thing only, my lord.
Only the pension part,
Yeah.
it will have a ramification in the state exchequer.
Yes, sir.
They are finding some, and there may be some lack of formalities,
So that
or
is-
maybe non-completion of certain formalities.
Understood.
That appears. So simply saying that no, pension also for all time to come, you will get as a principal, that may not be very proper without an inquiry. But at the same time, you have also retired. We want to protect your interest to
Maybe,
some
my lord,
extent.
on the basis of the, suppose at the time of retirement, what was due to him, suppose. On that basis, pension may be calculated.
No, that is what you are getting as a principal. They are saying that, in fact, on facts, you are not entitled to hold the post of
Right.
principal.
But I had,
That we are not saying anything.
Yes,
He may
sir.
be right, you may be right.
yes,
And without inquiry, we cannot come to a conclusive finding that whether whose allegations are correct.
so,
under
at
49
first, my lord, headmaster's.
How do you
case-
balance this? We don't
Headmaster-
want to prolong this. You are a retired person.
Well, in that case, headmaster's scale, my lord, whatever headmaster's say,
Yes, yes,
it may be, my lord.
Yes, yes, that
I
is-
think
that
it
is
may be reasonable,
Uh,
off the record, my.
yes, yes.
I-
That is what, that is what.
In fact, well, under 49C also he is not entitled. 49 FR 49C.
That is for additional charge.
Additional.
Yes.
That-
If we are taking it an additional charge also, my
No,
lord, as a
no,
principal.
additional charge is not there, of
Then
course, he is,
Right.
but he
No,
himself.
Mr. Khatuniya, 49C perhaps will not come. 49C is when you are holding a substantive post, that apart you are given additional charge for which you will not be paid.
Yes, sir.
Now he was holding the substantive post of headmaster.
Yes.
School itself was provincialized and made
Upgraded to-
upgraded.
Upgrade,
So you cannot say that he is now additionally,
yeah.
it's only one post.
Only that may be, my lord, the suggestion I made, my lord, maybe headmaster's scale,
Yes,
without recording
Uh,
from my
okay.
mouth, my lord.
slightly critical, but we'll solve it. We'll resolve it.
My, the other things, what pension benefit, leave salary, etc.,
On that, there is-
area,
yes.
something.
Okay. Is there any interim order?
No, not to recover.
Not to
In
recover.
No,
fact, the second
recovery.
rate petition, there is an interim order, not to
Okay, not to
recover.
recover.
Yeah, no.
Okay. Both these writ petitions being connected and filed by the same petitioner, those were heard analogously and are disposed of by this common judgment and order. Full stop. Para. The petitioner, the controversy raised in these matters is connected, is related to the action of the respondents in completing a disciplinary proceeding culminating in an order dated 10/8/2015 of recovery from the pensionary benefits of the petitioner. Full stop. Para. Bereft of the details, the facts projected is that the petitioner was the founder headmaster of the Chor CHR Anchalik High School established on 1/3/1982. Hereinafter called a school, The said school was provincialized on 19/11/1991, and the petitioner continued as the headmaster. Full stop. The school was upgraded to a higher secondary school, and the petitioner continued to act in the post of principal of the upgraded higher secondary school. Full stop. Vide an order dated 25/3/1996, it was directed that the headmaster of the high school will act as the in charge principal of the higher secondary school. Full stop. The petitioner had submitted representation on 10/11/2011 with a request to give the status as a regular principal, and the aforesaid representation was forwarded by the Inspector of Schools, Nalbari, vide communication dated 19/1/2012. Full stop. However, instead of taking care of the situation, an order of 16/9/2014 was passed, by which the petitioner was placed under suspension. Full stop. The petitioner had accordingly preferred an appeal under Rule 14 of the Assam Services Discipline and Appeal Rules 1964 hereinafter called the rules against the aforesaid order of suspension. Full stop. The authorities thereafter had issued a show cause notice on 20/10/2014, which the petitioner claims to have replied on 28/10/2014. Full stop. However, another show cause notice dated 2/1/2015 was issued. Full stop. It has been highlighted that the issuing date of this show cause notice was 7/2/2015, and it was served on the petitioner on 12/2/2015. Full stop. In the meantime, on 31/1/2015, the petitioner had retired from service on attaining the age of superannuation. Full stop. The petitioner thereafter had filed the first writ petition, WPC 3254 of 2015. Full stop. During the pendency of the same, the impugned order dated 10/8/2015 was passed, which is the subject matter of the second writ petition. Subject matter of challenge in the second writ petition. Full stop para. I have heard Sri H.R.A. Chaudhary, Learned Senior Counsel, assisted by Sri F.U. Borbhia for the petitioner. The Education Department is represented by Sri N.J. Khatonier, Learned Standing Counsel. Full stop para. Sri Chaudhary, the Learned Senior Counsel, has submitted that the allegations are without any basis, as at no point of time, any misconduct of the petitioner can be pointed out. Full stop. He submits that the high school was upgraded to a higher secondary school, and the action of the petitioner to act or as the principal of the upgraded higher secondary school was within the knowledge of the authorities. Full stop. It is submitted that the letter dated 19/1/2012 of the Inspector of Schools, Albury, would bear testimony to the fact that all actions taken by the petitioner were within the knowledge of the authorities, and those were done in the greater interest of the institution. Full stop. Para. Apart from the lack of any basis for leveling the charges, the learned counsel, the senior counsel, has submitted that there is gross violation of the procedures laid down in the rules of the rules of 1964. Full stop. By referring to Rule 9 of the said rules, and it is submitted that the charges are required to be proved on the basis of evidence. Full stop. Though in a given case, the disciplinary authority may act as the inquiry authority, the procedure for establishing the charges cannot be dispensed with on the mere pretext that no defense statement was furnished by the delinquent employee. Full stop. It is submitted that in any case, there was a clear denial of the charges by the petitioner in his reply dated 28/10/2014, and the said denial has been overlooked. Full stop. The senior counsel submits that even assuming that there was no reply, a disciplinary authority cannot come to a conclusion of establishment of the guilt without holding an inquiry, which would further require the said authority to forward a report of the findings in the inquiry so as to enable the petitioner, the delinquent, to offer his views on such findings. Full stop. Para. By drawing the attention of this court to the impugned order dated 10/8/2015, passed by the Director, Secondary Education, the learned Senior Counsel has been critical of the considerations and has submitted that the conclusion has been arrived on presumptions and without following the prescription of the rules. Full stop. He submits that the order of penalty is unduly harsh, as there was no misconduct as such on the part of the petitioner. Full stop. The learned Senior Counsel has pointed out that in the second writ petition, there is an interim order in operation whereby recovery of any amount from the petitioner has been stayed. Full stop. Para. Per contra, Sri Khataniar, the learned Standing Counsel, has submitted that the requirement of inquiry would come only in case of denial of the charges. Full stop. He submits that the petitioner never replied to the show cause notice dated 20/10/2014 and the reply dated 28/10/2014, which has been claimed to have been filed by the petitioner, was never received. Full stop. The Standing Counsel, learned Standing Counsel, has also drawn the attention of this court to the appeals filed by the petitioner on the under section 14, under rule 14 of the rules, and has submitted that in the said appeal, the petitioner has accepted the charges, and therefore, there may not be a further requirement of establishing the chase charge in view of the admission. Full stop. Para. The learned Standing Counsel, on the merits of the charge, has submitted that the petitioner could not have acted as the full-time principal of the upgraded higher secondary school in absence of a formal order by the competent authorities, and that itself is a misconduct. Full stop. It is submitted that there is a difference in the post of the headmaster of a high school and the principal of a higher secondary school, both in terms of responsibility as well as the financial aspect, and these and the action of the petitioner in assuming himself to be the principal of the upgraded higher secondary school without any formal order clearly appears to be an action not contemplated by law. Full stop. The learned standing council has also tried to clarify that the forwarding letter by the inspector of schools dated 19/1/2012 would not vest any right to the petitioner to make the present claim. Full stop. Para. Sri Chaudhary, the learned senior counsel, in his rejoinder has submitted that there was never any admission by the petitioner to the allegations leveled. Full stop. Apart from the communication sought to be relied upon by the department by construing the same to be an admission, being an appeal under section 14, under rule 14, pertaining to the aspect of suspension, there is no admission of any allegation as such, and the petitioner had only explained the factual aspects. Full stop. Para. The learned senior counsel has placed reliance upon the following case laws towards its submission, that when the procedures prescribed in the rules are violated, any order or penalty is not sustainable in law. Duta case laws, 1, 2. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully perused. Full stop. The facts which are revealed from the pleadings and materials on record would show that the school, the high school, which was established in the year 1982, had the petitioner as the founder headmaster. The school was provincialized in the year 1991 with the petitioner as the headmaster. And the same was upgraded to a higher secondary school. Full stop. At that stage, the petitioner started to act as the principal of the upgraded higher secondary school. Full stop. Though such act, per se, may not be strictly in accordance with law, for all practical purpose, the action taken by the petitioner may be out of necessity. Full stop. What is also striking is that after such upgradation, the petitioner, there is a communication dated 25/3/1996, whereby the headmaster of the school was allowed to act as the in-charge principal, which obviously meant that the petitioner would act as the in-charge principal. Full stop. Though there is a distinction between acting as a regular principal, distinction between discharging duties as a regular principal and an insurance principal, comma. There is another communication dated 19/1/2012, whereby the request of the petitioner to make him a regular principal was forwarded by the Inspector of Schools, Albury. Full stop. Though the learned counsel for the standing counsel for the department would be correct in contending that such forwarding letter may not vest any right on the petitioner. What is of importance is that the authorities were very much aware of the position existing in the school. Full stop. Nonetheless, comma, the petitioner was placed under suspension on 16/9/2014, pending in contemplation of a disciplinary proceeding. Full stop. The petitioner had indeed preferred an appeal under Rule 14 of the Rules of 1964, which provides for filing such appeal against orders of suspension. Full stop. So, full stop. Therefore, comma, the said appeal cannot be construed for any purpose to be any reply to the allegations leveled. Full stop. That apart, comma, the contention made on behalf of the department that there is an admission of guilt in the said appeal does not appear to be correct. Full stop. This court has closely perused the contentions, the statements made in the appeal. Full stop. A candid disclosure of facts cannot be construed to be an admission of guilt. And in the said appeal, comma, all the facts have been stated in details. Full stop. Para. As regards the so-called notice dated 2010/2014, comma, the petitioner has brought to record a reply filed by him on 28/10/2014. Full stop. Though the department has denied receipt of any such reply, comma, the petitioner was served with another show cause notice on 2/1/2015, wherein the allegation is substantially similar to that of the first so-called notice dated 2010/2014. Full stop. Whether such a course of action is permissible without a proper explanation is whether such course of action without is itself a debatable issue, comma, the impugned order dated 10/8/2015 would reveal that the disciplinary authority by the said order had imposed a penalty upon the petitioner without even holding an inquiry or by following the other mandatory provisions required in a disciplinary proceeding. Full stop. The Director, Secondary Education by the impugned order dated 10/8/2015 has come to a conclusion of establishment of the guilt on the basis of an assumption that there was no denial oblique reply to the charges made against the petitioner. Full stop. Even if it is assumed that a delinquent had not filed his statement of defense, that will not automatically mean that the allegations are admitted and the requirement of establishing the same can be dispensed with. Full stop. The requirement of law to grant adequate safeguard to a government employee is a mandatory requirement which would require the disciplinary authority to ensure that all reasonable safeguards are afforded to such a delinquent. Full stop. Such reasonable safeguards would include, amongst others, to have the materials against the delinquent proved in an inquiry by competent witnesses who are or who would also be subjected to cross-examination by the delinquent, assistance by a defense representative, opportunity to inspect documents, and etc. Full stop. With regard to the aspect of furnishing, the rules holding the field allows the disciplinary authority to act as the inquiry officer. Full stop. No, it don't. Full stop. The question of the requirement of furnishing a report of the inquiry officer, if the same is a record of the inquiry officer to the delinquent to seek his views, is also held to be a mandatory requirement even after the 42nd Amendment of the Constitution of India by the Honorable Supreme Court in the case of Union of India versus Muhammad Ramzan Khan, reported in so-and-so. Full stop. It has been explained that though by the aforesaid amendment, the requirement of informing the delinquent of the penalty sought to be imposed has been dispensed with, the requirement to have his views on the findings of the inquiry officer would still be there, and in case such requirement is not given, the proceeding would be vitiated. Full stop. In the instant case, the impugned order dated 10/8/2015 does not indicate that even a semblance of an inquiry was held, whereby the charges against the petitioner were proved. Full stop. Para. In view of the aforesaid observation, wherein this court has noticed gross violation of the procedures laid down in the rules of 1964, the culmination of the proceedings in the form of the penalty of recovery of the entire amount drawn by the delinquent government servant as principal is set aside. Full stop. Para. Though, notwithstanding that the impugned order has been set aside, it appears from the materials on record that there was no formal order allowing the petitioner to formal order or posting of the petitioner as principal of the upgraded higher secondary school. Full stop. This court has also been informed that the petitioner has retired on 31/1/2015 and almost a decade has passed. Full stop. Therefore, to bring an end to the controversy finally and to shorten the aspect of any prospective litigation, it is while the impugned order of penalty dated 10/8/2015 is set aside, it is directed that no further recovery be made from the petitioner and for the period when he had rendered his service as the principal of the upgraded higher secondary school. Full stop. However, his pension is to be calculated in the scale which he would have been drawing as the headmaster of the high school at the time of his retirement. Full stop. The pensionary benefits may accordingly be released to the petitioner as observed above. Almost a decade has passed since his retirement. Full stop. Writ petition accordingly stands allowed in the manner indicated above.
It's almost just scale at the time of retirement.
Retirement, we have said.
And
Yeah.
other substantial allowance, other areas.
That has already been said to paid to you.
No, that has not been paid, man. That is also retirement.
Uh,
Other financial retirement benefit,
the
including allowance
the subsistence allowance
and areas
which is pending and arrears of salaries
along with
for the
other
period
retirement benefit.
where the petition till the petitioner had served are also to be released to him.
All right.
Also with the following direction. Okay. Both the writ petitions.
One date, he will give my note. Instead of, it will be 13P96 instead of 25P. Upgradation.
Upgradation we have not. 25/3 is you are treated to be as in charge principal. That is the letter. Upgradation we have not given any date.
Yes.
Is there a date for upgradation? Give the date of upgradation.
Yes, upgradation date is there, my upgradation page 35.
Date?
No, page 34, my
Please give the date.
page 34. Page 34, 21st May 93.
21.
Upgradation of high school into higher secondary.
21 May.
Yes,
1993.
man. Post sanction, my dot, page 35, 13 March 96.
21st of May 1993. Upgraded.
Upgraded. Page 34, page
Okay,
35, but post allotted on 13 March 96. Post by principal, etc.
13 March.
Page 35.
13 March.
13 March 96.
Okay,
Initially without post,
okay,
upgraded.
okay.
Post allotted 910.
Upgradation to a লিখি লবলো হ্যাঁ পিছত সোমাই দিবা the school was আৰম্ভ the factor the school was upgraded to a higher secondary school by an order dated 21/5/1993 full stop subsequently
Post was
by
allotted.
an order dated 13/3/1996 comma the post
Of
for
principal
the-
along with other
uh,
posts were allotted.
post for the higher secondary school including
Into the
the
principal
post of
with the
principal
scale of
were allotted. Okay.
of life. Oh, my dear.
This is by order, madam.
I have taken.
He is also not here. Tomorrow it may not be possible. You are not there in the second half. Okay, we'll accommodate you. 7 to, we'll have it next week, next Wednesday. On the prayer of Miss M.D. Bora, Learned Standing Council Cooperation Department. List on Wednesday next, huh? Okay.
Item number, supplement to item number 30, yesterday's matter which was shifted to today. Still number, it's 18 matter.
Okay.
It was considered part of it, but was kept for
We'll
today.
have a date. Second half, there is a larger bench.
Therefore, if it can be fixed for Tuesday, since 2018 will come on the top matter, we can.
Tuesday to vote matter আছে নাকি? কোনটা?
Or on a Thursday
Tuesday,
matter?
Tuesday, Tuesday. হ্যাঁ? Roster change হবে নাকি? Cannot say. Tuesday we'll fix it. We'll take a chance Tuesday.
Sir, items, I'm sorry, Mil. Item 6, my lord. Can it be taken up any date in the third
He'll
week
give
of?
dates, he'll give dates.
My-
Dates, any matter where interim order is till today? No. Otherwise, the court master will give dates if there is
Mine.
urgency, otherwise, no.
Much.